All right, everybody, we're continuing here in chapter 5, talking about civil rights. We're going through slides 30 through 38. We're going to talk about the continuing struggle for equality for LGBTQ individuals. And what we need to know about this is that, again, you're looking at the 14th Amendment's Equal Protection Clause, but now you're looking at the Due Process Clause. And what's interesting about the push for constitutional rights for same-sex relations or something of that nature is that the court uses equality, but they also shift and they consider the issue of LGBTQ rights as a liberty issue. Well, how do you get to that from a constitutional perspective? Well, you got to look at the Due Process Clause of the 14th Amendment to get there. And so there's four main cases. There's other cases, but there's four main cases that address this. In Romer v. Evans in 1996, it was a case where the people of Colorado, through a referendum, voted and they said, listen, marriage is between a man and a woman, and that any type of economic benefits for marriage will only be given to marriages between a man and a woman, not same-sex couples. Well, that got challenged. It went to the Supreme Court, and the Supreme Court struck it down. And what was interesting about this case is they struck it down because they said that the people of Colorado are projecting animus towards LGBTQ people. In other words, they said, for lack of a better way of saying it, that the people of Colorado were being hateful in some respect to deny same-sex couples the same marital rights as heterosexual couples. And of course, the pushback from Antonin Scalia in that case was, no, the court has mistaken a Kulturkampf for a fit of spite. And a Kulturkampf is the German word for culture war. And what he said in that case was effectively, the court is mistaking animus when in fact, the people of Colorado have a moral aversion to homosexual conduct that is not hateful. It is a moral issue that people sincerely hold. You've misconstrued the issue. But nevertheless, that decision was upheld in Romer v. Evans. Fast forward from 1996 to 2003, in Lawrence v. Texas, this was a case that struck down Texas laws and other laws that criminalized homosexual conduct. And then again, as we're looking at the trajectory of law that has led to same-sex marriage. And so it took a long period of time. If you move 10 years ahead from Lawrence v. Texas to the case of U.S. v. Windsor in 2013, there was a couple that was I believe, a female same-sex couple that were denied marital rights, and the court struck down the Defense of Marriage Act. Congress in 1995, upheld by a Democratic President Clinton and a Democrat-controlled House, they voted 95% in favor of the Defense of Marriage Act, that marriage is between a man and a woman. And in U.S. v. Windsor, they struck that down. And that in turn paved the way for the case of Obergefell v. Hodges, which upheld same-sex marriage as the law of the land. What's interesting about these cases is, again, this is the ongoing challenge when you're starting to deal with civil rights, or you're starting to deal with the 14th Amendment's Equal Protection Clause. What happens when one right is seeking the right of way at an intersection, okay? In the case of homosexual rights or same-sex relations rights, okay? What happens to other rights in the process? In other words, when the court gives one group, like same-sex, couples, rights, what happens to others? And that's the ongoing challenge. In other words, who has to give one group the right of way? But then in giving LGBTQ individuals the right of way, what does that happen? What happens to the rights of other people? Are their rights respected? So I'm going to look at, and again, most students understand Obergefell, and at least the idea of marriage as the law of the land since 2015. What many students don't understand are the constitutional implications of what happens when the court makes a social issue. In the case of same-sex relations, it could be abortion. It could be euthanasia. But when the court recognizes a brand new rights, what happens to the Constitution when that takes place? And so if you look at slide number 31, you see that there are three implications of the court recognizing this new right of same-sex marriage or same-sex relations. There's religious liberty implications, there's moral implications of rational basis review, and there's implications with regards to democracy and federalism. And so we're going to talk about these. Again, I think it's important for you to understand that there's something they call the law of unintended consequences, is that suddenly when the court goes in one direction, there's consequences that perhaps were maybe not seen as clearly. And so again, the first issue is the issue of religious liberty. And so in the Obergefell decision, Justice Clarence Thomas was mentioning in his dissent, okay, if we go in this direction, fine, but what about churches? What about Christians? What about people with sincerely held religious beliefs that have a moral aversion to same-sex marriage? What if the pastor of a church suddenly now is forced to perform a same-sex marriage ceremony, but they have sincerely held religious beliefs against that? Will they be punished for that? And isn't that wrong? So here's what he says in his dissent. Aside from undermining the political processes that protect our liberty, the majority's decision threatens the religious liberty our nation has long sought to protect. Numerous amici, even some not supporting the states, have cautioned the court that its decision here will have unavoidable and wide-ranging implications for religious liberty. In our society, marriage is not simply a governmental institution. It is a religious institution as well. Today's decision might change the former, but it cannot change the latter. It appears all but inevitable that the two will come into conflict, particularly as individuals and churches are confronted with demands to participate in and endorse civil marriages between same-sex couples, okay? And so Justice Thomas's point was very, very prescient, because that's exactly what happened, at least in the case of individuals who were photographers for weddings, individuals that were cake bakers for weddings. What if somebody has a sincerely held religious conviction that same-sex marriage is morally inappropriate? Can that person refuse to bake the cake? Can that person refuse to photograph that ceremony? And so a case came up that addressed that very issue called Masterpiece Cake Shop versus Colorado Civil Rights Commission. And this involved a baker by the name of Jack Phillips, who, when presented with the proposal to bake a cake for a same-sex marriage ceremony, he said, listen, I am a Christian. I have sincerely held religious beliefs that I should not do this. And so here's what I'm going to do. There's a number of bakers in the area, in the Denver area, that will perform this ceremony, they'll bake this cake for you. Here's the list, but I can't do it. But I'm going to provide, a way out. Well, that should have settled the issue right there, and the same-sex couple should have looked at other bakers. But they wanted to make this an issue, so they sued him, and it went all the way to the Supreme Court. So now you've got an issue where, again, you've got a same-sex couple that wants to get married. You've got a Christian baker who said, listen, I have to bow out on this thing, but here, I'll give you another group of other people that'll do it for you, no problem. Can this baker be compelled to bake that cake even if his conscience says he shouldn't? Okay? And the issue before the court was not so much religious liberty as it was compelled speech. Can the government compel somebody to speak something that they don't want to speak? Okay, so again, the idea here was baking a cake was symbolic speech. We've already kind of addressed that earlier in this chapter, or actually earlier in the civil liberties chapter. And so it became a symbolic speech case. So what the court said was, no, the government may not, and private individuals may not compel somebody who's got sincerely held religious beliefs to not bake a cake for a same-sex couple. They may not be compelled to do that because you're forcing someone to speak something, so to speak, symbolic speech, that goes against their conscience. And so it became more of a freedom of speech case, but it did have some religious liberty implications, okay? So the second, again, implication of, or consequence of legalizing same-sex relations involves, again, the challenges to morality. Okay, remember the rational basis test? The government has a rational reason for maybe prohibiting, legalizing prostitution, or legalizing a recreational heroin, or legalizing some other drug. In other words, there's a moral reason why little kids shouldn't take drugs, or a moral reason why people shouldn't become addicted, or something of that nature, right? Well, in his dissent in the Lawrence v. Texas case, which decriminalized same-sex conduct, Justice Antonin Scalia said, what we've done here is we've made morality not a rational basis for law. Be careful if you go in that direction, because it might lead to a Pandora's box kind of scenario. So here's what he says in his dissent. The Texas statute that made homosexual conduct illegal. The Texas statute undoubtedly imposes constraints on liberty. So do laws prohibiting prostitution, recreational use of heroin, or for that matter, working more than 60 hours a week in a bakery. But there is no right to liberty under the Due Process Clause, even though today's opinion repeatedly makes this claim. The Texas statute undeniably seeks to further the belief of its citizens that certain forms of sexual behavior are immoral and unacceptable. The same interest furthered by criminal laws against fornication, bigamy, adultery, adult incest, bestiality, and obscenity. This effectively decrees the end of all morals legislations. If, as the court asserts, the promotion of majoritarian sexual majority is not even a legitimate state interest, none of the above-mentioned laws can survive rational basis review. And so again, Scalia is going, if we say we cannot provide a moral aversion, or we can't create laws that say, listen, we've got a moral aversion against same-sex relations. If you strike that down and say morality doesn't matter, well, then morality doesn't matter in laws prohibiting all kinds of other behaviors that are morally repugnant. And so it's an interesting argument he makes there, okay? And then the third issue that comes to play when same-sex relations or any kind of social issue is pushed by the Supreme Court, it impacts democracy, right? Because the court, 9 unelected judges, just went around the will of 330 million Americans who were still working through the issue of, in this case, same-sex marriage in Obergefell. In other words, not all the states were uniformly for same-sex marriage in the states. They were still wrestling it through. Well, when the court made the ruling in Obergefell, it pretty much muted, right? It muted the voice of the legislative process from state to state. And so democracy and federalism takes a hit. Because remember, states now are not able to weigh in on this social issue because the court makes a one-size-fits-all ruling. Okay, so again, Antonin Scalia pushes back, and he basically says, today's ruling says that my ruler and the ruler of 320 million Americans coast to coast is a majority of the 9 lawyers on the Supreme Court. He said basically, this decision robs people of the most important liberty they asserted in the Declaration of Independence and won in the Revolution of 1776, the freedom to govern themselves. Until the courts put a stop to it, public debate over same-sex marriage displayed American democracy at its best. Individuals on both sides of the issue passionately but respectfully attempted to persuade their fellow citizens to accept their views. And so he says, basically in his conclusion, to allow the policy question of same-sex marriage to be considered and resolved by a select patrician, highly unrepresentative panel of 9 is to violate a principle even more fundamental than no taxation without representation, no social transformation without representation. So again, the implications of this expansion of liberty for same-sex relations or same-sex couples or any social issues when the court weighs in, again, it impacts other rights of other groups of people. And again, as I record this in 2026, the implications are still being worked out. So again, it's always there's always trade-offs when the court recognizes new social rights. And again, this is why the founders originally felt that issues like morals or health or police power always should have been dealt with at the state or local level. But again, the 14th Amendment's Equal Protection Clause and Due Process Clause and selective incorporation has dramatically changed that. All right, I'll see you in the next series of lectures.